Lord, that the state, while these proceedings were pending in the High Court for appointing CBI for investigation, and proposal was mooted, Lord, with respect to appointment of those who were in the waiting list, which obviously could not have been done, but that was approved, but never implemented. One person was appointed, Lord, on the ground because suffering on with cancer and humanitarian grounds.
Thomas Sen or something.
Yes, and the High Court upholds that.
On humanitarian grounds.
Yes, that's right. Rest, there is no appointment. But what High Court has done is at page 281 in the relief, they said that now how this order was passed, an unimplemented order, how it was passed.
But Mr. Dwivedi, said the way this whole process has been done. Originally, NISA, NYSA, I presume it is NISA, appointed without a tender.
No, I'm not defending that.
Then that data fintech comes in place of NISA. The chairperson of the staff selection committee says, I don't know how they have come in. The OMR sheets are completely destroyed by the staff selection.
So that's a second issue.
The mirror images are not there on the server anymore.
Yes.
People who are not on the panel are recruited. I mean, this is completely, it's a fraud.
I represent those who are in the panel.
No, just a minute.
We were in the panel, we were appointed, we are substantive. And how did the High Court terminate? High Court is not the appointing authority to terminate people.
But my issue, let me complete my issue. Yes, this is a different issue.
Yes.
I'm not on the issue of how these people were appointed and whether CBI found 8,000 odd candidates whose name have been found. So that's one part of it, that because CBI finds 8,000, how do you set aside 23,000?
No.
All of them.
The whole process was replete.
No, but that's the second issue. I'm on the first issue. I'm more on the first issue, on behalf of the state. And that is, if your Lordship looks at page 281, this has nothing to do with that appointment.
Just one second.
At page 281, this is post-appointment based on that selection list. There were certain wait lists. To accommodate the wait list, page 281, number 8 at the bottom. The High Court has directed, Lord, that CBI will undertake further investigation with regard to the persons involved in the state government approving creation of supernumerary post. To accommodate illegal appointments if necessary, CBI will undertake custodial interrogation if necessary. Now, this is a case of creation of supernumerary posts for waitlisted candidates, which was never implemented, and only one person was appointed, whose appointment is upheld by the High Court.
So why was supernumerary posts created? Once they found that these appointments were illegal, High Court decides.
No.
The government decides.
At that time, there was no order of illegality. When this order was passed, there was no finding of the High Court about illegality. More than this, the state government passed the order in May, and up till November, no person was appointed. Then somebody challenged a writ petition, a separate writ petition, where that order was stayed. And that is a separate petition which is still pending before the High Court. And in this matter, an unimplemented order is a question of criminality. Illegality is one part.
Ultimately, it is only a direction to the CBI to undertake the investigation.
Well, it's very just total they will register an FIR, the whole cabinet is involved, the whole cabinet during election goes into the jail. There's another incident.
May I just add to what my learned friend is saying? These supernumerary posts, the object was that since there are these challenges pending to illegal appointments, let people at least in the waiting list, that was the thought, maybe right or wrong, would it be? Supernumerary posts be occupied by them so that there is no vacuum. A detailed cabinet note is prepared on the matter and placed before the cabinet. Now, ultimately, my lord, what is the import of this is that anyone involved in the preparation of the cabinet note, right till the approval of the note by the cabinet, can be interrogated by the CBI because and why were supernumerary posts created and taken into custodial interrogation. The important thing is this was never the subject matter of the writ that your lodges are dealing with. The impugned order arises out of a writ petition which has nothing to do with supernumerary posts or a cabinet note. That's a separate writ petition in the Calcutta High Court pending before a single judge where that cabinet note has been stayed. That's a subject matter of a separate petition. Now, Sunday in a division bench dealing with the issue of the larger issue of criminality picks up the cabinet note and says that the CBI can look into anyone who prepared the note or how these supernumerary posts were created. Now, to look at how supernumerary posts were created, you will look at the cabinet note, then you look at the officers and the cabinet.
We got the point. We hear the other side.
In this petition, there is no pleading at all about it.
No, but this is the wrong SLP. This petition was not hard.
Send us back to the High Court. The High Court says I will not be. Saying that your appointments are cancelled. We say that, Lord. High Court expressly said I won't hear you. And we turn to page 147.
147.
Para 147.
Where do we get that?
Yes, no. Para 147 and 124, sorry. 124
what?
and page 150.
Internal page?
Lord, internal page, just see para 124, ma'am, of the impugned judgment. We were before your lordships in the first round. Take it from my lord.
165.
165.
Yes.
Now see, Lord, 1 PDF page. PDF page 205. Para 124. In our understanding, all writ petitions relating to recruitment process initiated in 2016. Now, Lord, recruitment process started in 2016, completed in 2018, appointments issued. First writ comes in 2021. Justice Gangopadhyay takes it up and issues notice. That's the foundation of this appeal now. Was directed to be heard by division bench, but only those petitions relating to categories as noted above in respect of so-and-so and instituted so-and-so, and appeals arising out of orders passed in such petition. We have understood para 1 of the order of November 9, 2020, that's your lordship's order, to prescribe categories of matters as also time limit for filing writ petition. We have understood order of assignment of the Chief Justice in this context. Now see your lordship's order. Para 10 and 11 of your lordship's order. Lord 9th PDF page 9th November 2023. Just see that one.
Ninth November order.
কিছু হবে না মনে হয়।
Lord, kindly turn to Lord direction. The lordships have got direction.
Where is that?
Lord, a PDF page. 157 PDF page. Your lordship's judgment in the first round. Lord, our SLP was 7172 of 2023 before your lordships.
528, right?
Yes. Now, Lord, kindly turn to Lord paragraph 10.
যা শুধু ক্যাবিনেট বাঁচানোরই চেষ্টা চলছে। আমাদের কথাটা শুনছে, আমাদের কথা আর বলছেই না। ওই সুপার নিউমেরিক্যাল পোস্ট নিয়েই পড়ে আছে। টেকনিক্যাল প্রবলেম, ওখানকারই টেকনিক্যাল প্রবলেম, ওখানকার টেকনিক্যাল প্রবলেম। এই সময়ই প্রবলেম, সব টেকনিক্যালও প্রবলেম এই সময়ই দেখা যাচ্ছে। কি হলো?
Who was in Noida. He is an accused. He issued the certificate, an individual. I give you a certificate of 65B4. He is an accused in 464. That certificate is relied upon by the High Court to throw out everybody. That obviously what is recovered from him, that hard disk is gospel, and all you chaps do not have manipulated over. There are several questions which are right.
In fact, there is no challenge to our appointment. They are participating. Writ petition doesn't contain any prayer to set aside selection. No selected candidate is a party. No selected candidate.
Only waitlisted fellows are here.
4.5 years. All those points were raised.
And we are substantive. Our main fundamental point. How does the High Court terminate, If you are a substantive employee, you have to have an inquiry, That's the basic requirement of 311, that you have to have an inquiry. No inquiry.
Point.
The High Court terminates because the single judge, who is just now retired, the single judge terminate it. The court has no power to terminate. The court can direct an authority. Look at it. How does the court become an appointing authority to terminate 35,000 people?
We will show,
I must say,
These fellows will be out of job. There are 4 people per job, who are dependent, and 24,000 got knocked down.
May I have a moment?
This is something, which requires your lordship consideration.
May I have a moment, my lord?
but we have all been directed to be taken in custody.
Sir, I appear for the commission, my lord.
If there are other petitions,
Yes,
there are.
the numbers to the court master. So
We will give the numbers,
Taken in custody for
No, there's no such election. I appear for the commission, my lord. Kindly give me a minute. I appear for the commission, my lord. We have to taken out an appeal. We have, my lord, several issues to raise before your lordship, my lord.
Yes.
He had said that we are in a position to check up who are the tainted persons and who are the untainted persons. Because CBI only identified a few persons as being tainted. On that basis, my lord, the court says incorrectly that it is not possible to segregate. We have made a specific submission that we are prepared to segregate. Your lordship's judgment say that very much possible.
I find that the CBI report at page 281, that says that they have identified 952 candidates for 9th and 10th.
Exactly.
And about 907 for 11th and 12th.
Yes. So therefore, my lord,
CBI
that is, my lord, 10%, my lord, of a particular category.
That's 10%, Or 900, you throw out 9,000.
But that's a
Your lordships have said, if you can separate the trade.
Hard blood
yes.
proof that they're all corrupt.
Point.
There are 3 other issues that I need to highlight.
Your lordship judgment in 2001 in Delhi, my lord, South Election Commission.
All
94 other till in all such, my lord, where the records are not available, there is no question of ability to segregate any one of them, and therefore your lordship decided.
But the evidence has been accepted, so am I.
Undertaken, and all appointments have been set aside in all those cases.
It's my lord's own judgment.
High Court is not a power to do it. That's the High Court, my lord. Your lordship in Krishna Yadav said, if the records have disappeared and High Court has raised, then that I can't do anything. Your lordship said High Court should have enabled it and should have passed the order.
Then the High Court cannot go.
I need to highlight the huge scam, all the ministers others in custody.
Once again, then all other matters which are being filed now or which have already been filed at
Yes.
the board today, they be listed together. We'll keep this on next Monday.
My lord.
We just like some orders so that, if you can just indicate to us what are the categories.
Yes.
Because, there's no point.
4 categories.
So if you can just divide into categories, likewise also on your side, so that we have a clear picture of which are those categories in which these different cases fall.
That's right.
But the OMR sheet disappeared, no record.
But only one problem, 36.1 and 36 is not wrongly filed. These two SLPs but cannot be kept on record. I need to flag for issue.
Get it this way. OMR sheets are completely missing. The OMR sheets are destroyed.
No.
The OMR sheets are destroyed. It's
not under the-
even in the mirror server.
Court has accepted, my lord.
We'll have to demonstrate that finding is incorrect.
Not with great respect, under the rules. The OMR of 2016
Jobs
has
are
been
put in
written
the
in
market.
but the rules provide.
So how long do the OMR sheets?
2 years. 1 year. 1 year or 2 years. We are now 8 years out. How can you keep a record?
Yes.
Nobody
That's
can
the
keep
physical
record of
not to be
3,000 people. Not required.
220. But Mr. Rothi, consider this. If OMR sheets are now not available
Destroyed, yes.
for whatever reason,
Yes.
how do you separate the
Yes.
valid from the invalid?
They went.
That is, let them produce the OMR sheet before law.
So there are secondary material available.
Oh, what happened?
Everybody.
This evidence has been gone into by the court and the court says it is admissible.
Yes.
Under 65B.
That
They are
has-
challenging that, but if that is so, my lord, it can be verified. The CBI has used that material. The SSC has
But
accepted
he
that.
say the certificate should by an accused.
All of you demonstrate to the court that it is possible to say in all these matters. Question is whether you can segregate. I dealt with the Delhi matter, Ms. Dewan.
Yes. Sir, we are aware.
We said that it's not possible to segregate in that case. You have Kellon's case. They have cases on both sides.
Correct.
Both sides.
You have to demonstrate that on the basis of material which is available, it is possible to segregate.
Yes,
do that.
sure.
Those, because we quite see.
Let them show.
Terminate 25,000 people is of a very high order.
Yes,
Unless you are left with a situation where the entirety of the process is wrought with fraud.
That is no.
To us that there is material to indicate as to who are the beneficiaries of fraud and those people whose appointments are clearly not taken.
Yes.
There are 240.
Yes.
They prepare. So commission gives a table that these are identified, these are not complete, and we can't tell you how many more. Better commission admission.
No, Mr. Happy, it is an incorrect statement. We said we can.
We will have to hear the matter. It's not a matter which we can just
That's
but it will have T20 matter.
So it takes up plus on Monday, we shall clarify.
8 and 9.
We want some factual clarity.
Yes, sir.
Because when the matter opens, please make sure that whoever argues in an order. So there should be some element of clarity because the High Court may have added. They have seen the matter expound before themselves. We don't have it. But we'll look at it threadbare.
Absolutely, we are grateful.
Direction 8 and 9 should be stayed.
It's a wrong SLP file, my lord. The lead petitioners was not had there. It is completely different definition. Let them correct it.
All right.
Because direction 8 and 9 should be stayed.
What is happening between
Let them
Not this is election time and the cabinet.
I'll tell you, Lordship, what will happen
the
is
date of the judge?
that 22nd April. Now, that takes
That is right in the midst of election.
officers will be there, some on election duty, otherwise will be picked up right from the bottom till the top. Whoever was involved with the preparation of the cabinet note, whoever the CBI wants to take and pick up a custodial interrogation.
Even the cabinet, because the cabinet has passed the order.
Yeah, we are all
We are on election duty.
preparing for
I am for 39. I am waiting for your lordship to rise.
Oh, you're not in this.
I am not in this matter. 39. I have conveyed to Mr. I have conveyed to matter Bhushan.
So I'm in 38 where I said give me
Raju.
Oh, you're not in this matter.
No, it was 11,000 small persons who have been due for. I'm in that matter.
Yes, okay.
Lord,
Now,
I have conveyed to Mr. Bhushan, my lord, I have conveyed that the Honorable Court may take a call on my request if he is here, my lord.
We'll allow you to take copies of the report, Mr. Bhushan, and the report of the Secretary of the District Legal Services Committee, District Legal Service Authority, Achar, has been received. The registry shall supply copies to Mr. Prashant Bhushan, Learned Counsel for the petitioner, and the advocate instructing Mr. Tushar Mehta, Learning Solicitor General. We'll list it next Monday.
Monday, Malad? Please
Take it up next Monday.
I have a
Please allow.
request. Item number
Mr. Raju, your matter,
Yes.
we'll take it up, we take it on this week, or you want to take it up next week? You're supposed to give us a short.
No, I got
Just
it.
hand over the note to the court master,
I'll-
we'll take it up next Monday.
But in this matter also, CBI should be represented because CBI report is important.
Preparing for CBI in this matter.
In this matter, Mr. Raju had acted on principle.
You're not, it's not that bad. It's
No.
Are you appearing?
Cam,
Raju, or-
We will appear, Malad. We are, today we are not here for that matter. We don't have papers. But if they can give, Malad.
Yes, let someone appear. That's the
Petition to Mr. Raju or Solicitor General.
Manoj, I'm told we have served. Mr.
Give an additional copy.
Very well, Manoj. But in the meantime, no precipitative steps in terms of full signal.
Because we are also asking for stay. We are on election duty. There are we do go now.
Nothing is going to be affected.
I'm sorry, we can't go home.
1 second.
Our employment stands terminated as of today, Lord.
There are we do
terminated.
Proxy will grant an order of status quo.
The whole
Every officer of the government who is involved with the cabinet board can be picked up today as per this direction.
Status quo means of your service. I get status quo. Don't complain.
Every officer
Any stay would amount to a sanction to the corrupt appointment.
and the supernumerary posts can today be arrested for custodial interrogation if direction 8 and 9 are to be implemented.
The apprehension arrest will be taken care of, but nothing else.
I collect this them into custodial.
And this is when a single
Investigation.
single judge of the same High Court has stayed the cabinet note, an issue which is not argued, not before the division bench. You direct every.
Lord, I
But the judgment is.
Lord, I am making a request for 24,000 people. I
What
am
we'll do is, what we
requesting for a stay of termination.
Small Roman 8
Yes.
And 9.
para 363.
Lord, your lordship are going to have it on Monday, my lord.
But 8 says CBI will undertake further investigation with regard to
Yes,
the
8 and 9 is
involved.
sufficient.
8, insofar as 7 is concerned, we are not staying 7.
Yes.
But
8 and 9.
CBI will undertake further investigation with regard to the persons involved in the state government, approving creation of supernumerary posts to accommodate illegal appointments. If
Only 8 is enough.
No, so 8
CBI will only stay 8 at
Yes,
8.
Lord, what about 2? Our termination of 24,000 people.
Nothing more than that.
I've been serving for 8 years.
But I am not here for that, but I am not aware of.
This list on Monday, till next Monday ka date dal do. No precipitate step shall be taken in pursuance of the directions contained in small Roman 8
Yes.
of paragraph 363 of the Indian Judgment of the Order.
Lord, kindly consider our.
We'll see that after we hear everybody, but today we are just asking an order.
1,000 people should not be terminated.
Oh, they are all terminated.
Mr. Singh, we are seized with the matter. We are keeping it next Monday. The other petitions which have come in, today we didn't want something CBI to precipitate steps under clause 8. We are protected that. That's all.
We are grateful ones.
Because these are all illegal appointees without any.
Take care.
Yes, sir.
Can I
May I have
can I
my lord's
take a lot
indulgence?
of Very grateful.
My lords, may I have my lord's indulgence?